All right. Good morning to everybody. Welcome again to our training on the new and improved 504. We're going to get started now. My name is Charlie Michel, and I'm the presenter for this training. Today, my co-host is going to be Wallace Johnson from Families Helping Families of Southwest Louisiana and Lake Charles. This training will cover some of the basic points about Section 504. Now, in order for us to continue to receive funding to provide these free trainings, I'm going to ask that you please complete an evaluation at the end of the training. The evaluation results help us to improve trainings and demonstrate the need for continued funding to provide these types of trainings free of charge to our community. You will be prompted again at the end to complete the evaluation, and it should take you less than 2 minutes to complete. Everyone completing the evaluation will receive a copy of this PowerPoint and a certificate of attendance. But as an added incentive, everyone who completes and returns the evaluation within 24 hours of the workshop will have their name entered into a contest in which one refurbished laptop computer will be given away at the end of each month. So all the trainings we do in November, anyone that participates, we will put your name in there. If you participate in more than one training, we will put your name in there for each time that you're in there. We draw a name at the end of the month, and that person will receive a free refurbished Dell laptop. Now, as we're going through, if at any time you lose your audio, please rejoin the presentation using the login information you received in the invitation that you got through email after you registered. Participants are encouraged to submit questions in the chat box or wait until the end for question and answer time. There will be someone monitoring the chat box, so if you ask the question, he will let me know. Wallace, my co-host, will let me know that we have a question, and we will answer it at that time. BioLand Families Helping Families and Families Helping Families of Southwest Louisiana provide dozens of these webinars and in-person trainings on special ed and disability-related topics every year. We invite you to check out our calendar of events at BioLand's website, which is www.blfhf.org and www.fhfswla.org on a regular basis, and register for any upcoming trainings that might be of interest to you. Our web addresses are going to be included at the end of this on the slide for contact information so that you can use those whenever you might need them. We also invite you to request specific trainings that are currently not being offered. Chances are, if you're interested in a topic, someone else is too, and we'd be happy to develop that and provide it. So now, Wallace, would you like to tell the participants a little bit about yourself?
Good morning, everyone. I'm glad that you're here. I'm on staff at Families Helping Families of Southwest Louisiana, and I'm an education support specialist that we have at Families Helping Families. So if you're listening or tuning in from Southwest Louisiana, you know, I'm one of the education specialists that you talk to. We have two more. And thank you again, everyone, for being a part of this webinar. And we hope that you get some valuable information today.
All right, thanks, Wallace. Now, part of being successful in what we do is having partnerships with others that promote the same ideology as we do. We at BioLand and Families Helping Families of Southwest Louisiana believe that all individuals with disabilities, regardless of the severity of those disabilities, have the right to live a meaningful life, and to the greatest extent possible in their least restrictive environment. We recognize that this will look different for each individual. However, we believe that exclusion in any form is unacceptable as a long-term goal. The state partners that we have that help us with this to achieve these goals are, first, the network of Families Helping Family Centers, which includes 10 independently operated family resource centers across the state of Louisiana. This network, which includes Families Helping Families of Southwest Louisiana and BioLand Families Helping Families, provides support around a variety of disability-related topics. If you have a disability-related question, contact your local Families Helping Families Center for assistance. That's who we are. That's what we do. And another of our partners is Family to Family Health Information Center. That's a program of BioLand Families Helping Families, which assists families of children and youth with ages birth to 26 who have special healthcare needs, mental or behavioral issues, disabilities, and/or medical concerns. And finally, our third partner is Louisiana's Council Advocacy Network, also known as LACAN, which is a grassroots network advocating for inclusive education as well as individual and family supports and services. You'll find links to all three of these on the slide. Well, as soon as I can get the slide progressed.
You might have to reshare again.
There we go. Can you see it now?
Thank you, sir. Yes, sir. I can see it now.
All right, thanks. Keep me straight, Wallace, please. All righty. I need to start presentations. We all need to start presentations with this very simple statement. I'm not a lawyer. Please understand that I'm not a lawyer. So what I'm giving you is not legal advice. But when you ask a question and I answer them, and I will be able to answer most of them, I believe, the responses that I give will always be in the context of what I think might probably happen in most situations. And the reason I say that is because your situations as you describe to me might be excluding certain facts that might change the outcome based on the law. So just know that in likely circumstances, the answer that I give you will probably happen, but it's no guarantee. Hence, I'm not a lawyer. Now, as we go through this training, as I told you earlier, if you have any questions, please type them in the chat box. We'll monitor it. And we'll also have a section at the end of the presentation where you can ask your questions. And please, there is no stupid question. And no, that's not a challenge, but there is no stupid question and there is no question too large or too small. Ask it. If I don't know the answer, I will find it out and get back to you. But even if you think you should know that and you don't, I'm guaranteeing you that if you don't know it, someone else on this presentation that's participating won't know it either. So ask away. That's why we're here. All right, 504 is a very broad topic and covers a wide spectrum of issues from public building access all the way to educational access. Today, we're going to focus only on the educational issues that are relevant to your child's obtaining educational opportunities to the same degree that a child without a disability would. Hopefully, before we finish this session, our goal is that you will have a better understanding of Section 504 and how it can be determined if your child might qualify for services under the umbrella of 504. Knowing about 504 is the first step in you being able to help your child to determine if they are eligible and what supports can be provided if they are eligible. And lastly, today, I'm hoping that we'll be able to offer you some insight on what kind of accommodations might be appropriate in order for your child to better access the instruction at school that is offered to all students. All right, now I'm putting up a poll. What you see here is the poll, but I'm gonna put up an interactive page. And if you would, I'm gonna ask that you please, on your computer, answer these questions. And what we're doing is we're asking these questions at the beginning and then we'll ask them at the end again. My hope is that at the end, you'll have more of the information, so more of the questions will be correct than it is at the beginning, which will mean that the training has added value to your knowledge of 504 and services related to 504. That's how we can determine if we're doing what we need to do. If I see that there's not a lot of growth, new information coming on, then we'll modify the presentation so that we can be helpful to anyone in the future who might participate in this training. So if you just take a couple of minutes, just a minute or so, answer these questions. No one else is going to know what your answers are, so don't be worried about me sharing this. That's not going to happen. I will know what the overall responses are. And again, that just helps me to be able to determine where we need to beef up the training. And I'm just going to give you all a minute or so. Looks like about half of y'all have, I don't know who it is, but I can see that 7 people have responded. So I'm just going to wait another minute or so. And as Wallace said, I'm really glad that y'all are here. 504 is a very nebulous topic, and sometimes school systems don't have a great understanding of it. And I don't know that I put this in here in this particular training, but there is no funding for 504 either. So it's very beneficial for everyone to know what the availability of 504 services is and how you can best access them. Because since there is no funding, sometimes you have to know what those services are so that you can request them because they might not be offered to you. That is wrong, but it is just a reality. All right, I'm going to end the poll now. It looks like about 11 of y'all have done this. So in 5 seconds, I'm going to end the poll. So if you could hurry up and submit, that would be awesome. And I thank those of you who did participate in this. You will see this again at the end. The only difference is it won't say pre-check, it'll say checkup. All right. Now, before we get started, with the nitty gritty of the presentation. I want to share with you some information about me so that you can determine if I'm a credible presenter. I believe I am, but I'm going to let you judge that. But I want you to be able to know how much weight you can put on what we say, given my experiences. So the next few slides, I'm going to tell you a little bit about what I do. In the past many decades, I've earned a bachelor's degree in psychology, a master's degree, and a plus 30 in educational administration and supervision from Nicholls State University, which is in my backyard. When we moved to Texas, my family and I moved to Texas, I attended Sam Houston State University in Huntsville, Texas, where I earned a doctorate in educational leadership. For the past 3 years, and yes, for my employees, it seems like much longer, I have been the executive director of Bioland Families Helping Families. For the 10 or 11 years prior to that, I served as the special ed director in Lafourche Parish Schools, which the parish seat is Thibodaux in Lafourche Parish, so we're in Southeast Louisiana. The last 3 of those years, I served as the District 504 coordinator, and that's where I started learning a lot about 504. I learned a lot about 504 that I didn't know because of questions that parents asked me, that teachers asked me, that administrators asked me, and that the superintendent asked me. I had to research that. So for 3 years, I was knee deep in 504, and it probably is one of the most, other than being special ed director, it's probably one of the most knowledgeable experiences that I've had because I had to do so much research. Prior to that, for 7 years, I was a middle school principal in Texas. I was a high school principal for 1 year in New Orleans. I taught special ed in the classroom for 10 years at the elementary level and the alternative level. And I taught 4th grade for 1 year. And I taught 4th grade for one reason and one reason only. I love the kids. I love the grade level. I love kids at all ages. I really do enjoy being with them with all their uniquenesses. But I taught 4th grade because 4th grade, when I was in Texas, that was the grade that all tests, it was called TACS, but it's the equivalent of LEAP. All the tests were given. The teachers were exhausted, and I'm not going to say they complained. They just were exhausted, and they opined that it was a lot of work for them. It was a lot of work for the kids, and they were right. Then they saw that I had 6 students, and they said, well, if I just had 6 students, because I was doing inclusion at the time, if I just had 6 students, then I would be able to do this too. So why don't we trade places? And it was a 2nd grade teacher that told me that. Now I got to tell you, I love kids in 2nd grade and 1st grade and kindergarten, but I don't know if you've ever been in a kindergarten or 1st grade classroom, but it's like trying to lasso Jello. Those kids are all over the place, and I just don't think that I had the skills to do it. But 4th grade, I liked. They were old enough. They were able to do what they had to do. So I talked to the principal and said, let me teach, because the teachers didn't think that inclusion was viable. They had never done inclusion before. Let me teach 4th grade. You have an opening. I have the certification. Let me teach it. Well, I don't know if I'd have been as brave as she was, but she let me teach it. I had never done regular ed before. And the only thing was I got the kids, and I told her, I said, give me anybody that nobody wants to teach, and I will take them. I don't care if they're 504. I don't care if they're special ed. I don't care if they're behavior problems. I just don't want talented and gifted students because I didn't want that big of a spread. I thought that would be a little bit taxing for a 1st year general ed teacher. So she did it. Out of the 21 students that I had, 17 were special ed or 504, and then I had 4 other kids. So basically I had about 7 special ed kids because 504 is general ed. So it was a legal environment for all the kids, and I did that. Well, I loved it. And we had a very successful year. And I proved to the teachers who said that my job was easy, that their job was doable for sure. So that was 1 year. And then I got promoted to assistant principal at a high school after the 1st year. So that was 1 year that I think most of my career I made a difference with kids. That was the year I think I really made a difference with teachers, even more than when I was a principal or a special ed director. So I'm really proud of that. But as I said, that's what I do. But now I want you to know who I am. I know these pictures are a little odd, but that's just my wife and me. We've been married for almost 45 years. We had a photo shoot, not a photo shoot. We had a friend of the family come and take some family pictures because we'd never had them before. And when we were just horsing around while we thought she was changing her film, apparently she was not. She just took some candid shots. But my wife and I have been married for almost 45 years. And during that 45 years, we have been able to produce 2 really remarkable children. And so in addition to being a husband, I'm a dad and a family man. And I think my proudest accomplishment is our 2 children and my family. I don't take a lot of credit. When I was a teacher, I didn't take credit for the successes of my students. When I was a principal, I didn't take credit for successes of my principals. And honestly, as a dad, I don't take too much credit for the successes of my children, even though both of them in many different ways have demonstrated great successes. But I do take pride in the fact that I think I'm a good dad. I think they would agree with that. I hate to ask them because they might tell me the truth, but I am a good husband and a good father. And being a dad, I think, is probably the most important thing that I've done in my life. I've been involved actively with them since day one for my son, who is now 41. So that's a long time ago. And my daughter is adopted, but I was involved with her from the day we picked her up in Guatemala till today, 30, and she's 30. She's gonna be 38 on Monday, as a matter of fact. When I leave here, I have to cook her meal. She wants a cake and some fried shrimp. So that's what we're doing for her birthday meal. But, you know, even more, if you broaden out, more than just being a dad and a husband, I'm also a brother. This is a family picture that I just really love. This was taken at my brother's house. I don't know if my mouse is working for y'all, but this guy sitting down next to my sister, it was his 70th birthday. And all of us drove from Louisiana to go to Winston-Salem, North Carolina, to surprise him for his 70th birthday party. And as you can see, we have one child, one girl, and there's 8 boys living, but we had another brother that has passed away. So I'm one of 10. And I have to say that my parents instilled in us the love of family and the relationship that we need to make, that the work we have to do to maintain those relationships. And I say this for one reason only. I attribute that to my upbringing in South Louisiana. I know we are very family oriented, and that is just part of who I am. So everything I do, what I do, is permeated by who I am. All right. So now, enough about me, as I'm sure you've said long before now. But let's get started with the meat and potatoes of today's presentation. Section 504 of the Vocational Rehabilitation Act of 1973. That's where it all started back in 1973. And it was passed to ensure that all people have equal access to buildings and opportunities, regardless of their disabilities. But when it was first passed in 73, it was geared mostly toward access to federal buildings. Buildings that were built with federal dollars, that had federal programs within them. This law was primarily designed to make sure that people with disabilities could access those buildings. But as time went on, people with disabilities and their families wondered why equal access couldn't be expanded past just federal buildings. So through their advocacy work and lobbying, which still goes on today, in 1990, the Americans with Disabilities Act, or the ADA, as you probably heard it called, was passed. The ADA is a civil rights law that prohibits discrimination based on a person's disability. And that expanded the scope of Section 504. But then in 2008, the ADA, Americans with Disability Act, Amendments Act, you're going to love this acronym, ADAAA, was an act of Congress effective January 1st, 2009. And that act amended, or that law amended the Americans with Disability Act of 1990 and other disability non-discrimination laws at the federal level of the United States. It sort of brought a bunch of different non-discrimination laws together. The act emphasized that the definition of disability should be construed in favor of broad coverage of individuals to the maximum extent permitted by the terms of the ADA, and generally shouldn't require extensive analysis. And we're going to talk about that in just a little bit. Remember that broad terms for the definition and shall not require extensive analysis. The act makes important changes to the definition of the term disability by rejecting the holdings in several Supreme Court decisions and portions of the EEOC's Equal Employment Opportunity Commission's ADA regulations. The effect of these changes is to make it easier for an individual seeking protection under the ADA to establish that he or she has a disability within the meaning of the ADA. And this is important because it sets up one of the fundamental differences between identification of a disability under Section 504 and special education under IDEA. You know, when I was special ed director and 504 coordinator for the district, I frequently got asked, who does 504 fix? It was a kind of a smart alecky question because they wanted to trip me up. So principals would ask me that, teachers would ask me that, and they were often surprised by my answer to the question, because the reason they were surprised is because my answer would always be the same: nobody. Then I would pause and let them think on that for a second because they think they had me. And after a few seconds, I would remind them, because students who are eligible for Section 504 services are not broken, therefore they cannot be fixed. Then I would go on to explain that the purpose of 504 is merely to level the playing field through accommodations, extra supports, and services. Many would then tread the dark waters of, well, that's not fair. And just for the record, I hate that expression because I told my kids growing up, life isn't fair. It's not supposed to be fair. And if somebody tells you it is supposed to be fair, you tell them their daddy says they're a liar. So I never got Father of the Year, but that's absolutely how I believe it. We're not talking about fair. So being the warm and wonderful, wise man that I am, when teachers, professionals would tell me that it's not fair, I'd calmly say, okay, so let's talk about fair. I would think that children in a wheelchair might think it's not fair that they can't walk like many of their friends. Teachers with significant seizure disorders might think it isn't fair that they can't drive a motor vehicle like most of their friends. The child who struggles just to be able to identify numbers and letters and has so much trouble reading might think it's not fair that their friends and peers have such a much easier time with reading. And you know what? Even though I hate the expression, those things really aren't fair, but it's a reality. 504 provides teachers and administrators the ability to level the playing field so that a child's disability doesn't inhibit his or her ability, to a point that opportunities for a child with a disability are fewer than those for children without a disability. Is it unfair that a child in a wheelchair uses an elevator to get to the second floor? Or does this just allow all students a way to get to their classes on the second floor? The elevator obviously allows the child in a wheelchair equal access to his or her classroom. So why is it unfair for a student who struggles to read to get extended time or test read aloud to complete his or her tests? The short answer is it isn't fair. It is not unfair. Now, there are many people who are involved in determining whether or not a student is eligible for 504 services before the child can even be eligible. And who will then be responsible to monitor the effective implementation and delivery of those services? In other words, once a child is determined eligible, someone has to monitor to make sure that that child is receiving the services identified after that eligibility process. While everyone in the meeting is extremely important because of what each brings to the table, it's the principal or his or her designee that is able to allocate the appropriate resources to ensure that all accommodations agreed upon by the committee will be available and provided. Because of the principal's very important role, the principal needs to be present for the entire meeting. If the principal needs to leave, pause the meeting. They may not want to, but you tell them, if the principal's not here, we're going to pause the meeting. Sometimes there are emergencies, and that's true. Those walkie-talkies, I think they still carry walkie-talkies around. They'll be buzzing. You know, there's a fight here, there's something here, there's something here, and they have to leave. But when that happens, let them excuse themselves and pause the meeting. Do not continue the meeting while they're there. I would never let a 504 meeting proceed without the principal present under any circumstances. And you do not, if the principal is not there, don't let the meeting start. Because what happens is sometimes you'll end up with what I call a drive-by meeting. And that's where the meeting is held with the parents and the teachers and maybe some other people in the meeting, but the principal's not there. Then the principal just signs off on it afterwards. Well, that's not his role. And it's not your job to tell them what their job is, but your job is to make sure that all resources are allocated and that the principal has had an opportunity to share with you that they would be allocated. So be very leery if a principal is not there, reschedule. If the principal has to leave and the emergency is longer than expected, reschedule. It is inconvenient, but it is absolutely in your child's and your best interest to do that. Now, many districts call it what's called the School Building Level Committee, or the SBLC. The chair of that committee, and it's called different things in different systems. I know, I believe Jefferson Parish calls it SBET, and some districts call it Student Support Team, so it's SST, but most school districts call it the SBLC, School Building Level Committee. And that chair, who's also called the 504 chair sometimes, is there to ensure that all topics of concern are addressed and that everyone who needs to be present at the meeting is informed of the meeting and its location, time, and purpose. As a parent, you have a right to know when it's going to be, where it's going to be, and what's going to be covered. The school system has the responsibility to let you know when it's going to be, where it's going to be, and what's going to be covered. Then the general education teacher is a required member because it's the general ed teacher who understands the grade level curriculum and what the student is expected to learn and how that knowledge needs to be demonstrated. Parent. Now, I didn't put you first. That doesn't mean you're not the most important or that you are the most important. I just put you in the order that I typically see the invitations going. You have a right, and I would argue the responsibility to be present to discuss your child's educational needs. You're not required, you are required to be invited, but if you choose not to attend, that is certainly within your rights. I would never make that choice. If it's a time that you can't attend, I would suggest asking for a different meeting time because you do have the right to make that request. Or if there's a different way you can participate. I know with COVID, we're kind of getting used to these Zoom meetings and the virtual format, but even before that, and now still, you can participate via Zoom, you can participate via telephone, and they can put you on speaker, so that way you're still there, part of the discussion. So this way the process becomes something, and also I would suggest that you have your child there. That is strictly your choice until they're 18. I'm a big proponent of having the child in all 504 and quite honestly IEP meetings, because this process becomes something that is done for the student and not something that's done to the student. And I think that makes a big difference on the student accepting accommodations or not, understanding what's being done and why it's being done. And I believe that's a teaching tool that is incumbent upon parents and the school to offer to that student. But it also helps the student to see others advocate, typically you, but the school system is advocating for your child as well. You may not always agree with what y'all are advocating for, but y'all are all advocating for your child. At least that's the goal. So let your child be present in that meeting so they can see different strategies on how to advocate. They can learn what things are appropriate and what things maybe they don't need, but they might want. And so they learn how to advocate for themselves. And self-advocacy is a skill that lasts forever. Once your child gets out of school, the world is a much broader place and a much more difficult place to navigate. So our goal as educators, and yours typically as parent, would be to give them all the tools they need to be successful outside of school. I also suggest that a pupil appraisal center person be at the 504 meeting, especially if they're going to be discussing an evaluation, because you want someone who is knowledgeable of the evaluation process, the instruments that we use, and also the nature of the disability and how that disability might impact your child's education. That's a critical component because that's how you determine eligibility. And then also, if they're eligible, what accommodations might be appropriate given the specific disability. Then there's anyone else who can come to the table and bring some information about your child's learning, behavior, etc. It could be someone that you want at the meeting merely for moral support. They don't have to be a professional. They don't have to be an advocate. They don't have to be a lawyer. Just somebody, a friend of yours that you feel like sitting next to you in a room with 3 or 4 or 5 other professionals makes you feel more comfortable. So you're feeling like you're more easily able to advocate for your child. You get somebody there for moral support, but it could also be an advocate and an attorney. The school system needs to inform you of anyone they're inviting to the meeting, but you don't have to let the school system know if you're bringing someone. However, as a courtesy, and this might be a bias since I'm a former school board employee, so take this for what it's worth, but I believe this firmly, let the school system know if you're bringing an attorney or an advocate at least. And the reason for that is it helps if the school system knows you're bringing an attorney, 99 times out of 100, they're going to want their attorney present. If you just show up with an attorney, you're going to end up paying an attorney because the school system won't be able to have the meeting because they have to have their attorney present as well, usually. And that's just inconvenient for everybody. I'm not saying don't bring an attorney. I'm just saying make the necessary arrangements so that your attorney and the school system's attorney can be part of the meeting at the same time. And it's just one meeting. It may take a little longer to get to it, but it's one meeting date and y'all don't have to keep rescheduling.
There's a question in the chat box.
Shoot.
Says if the principal isn't the person responsible for the 504, who is? You mentioned that it may be someone else, and
Yes.
maybe they're referring to the school building level committee chair.
All right. Now, what we've got, the principal is responsible for 504 to be in attendance at the 504 meetings. However, the principal can designate someone else to attend the meeting. So if the principal's not there, but let's say the assistant principal is there, then yes. That's perfectly acceptable. It's the designee. I would argue that the SBLC chair cannot serve as the designee for the principal because they would be serving dual roles. I would suggest that it needs to be someone whose sole purpose is to be there to discuss the IEP, I'm sorry, the IAP in the context of your specific child's specific needs, so that they can know and allocate the resources that are available. So that, yeah, that's a good point. The principal is ultimately responsible, but it's the principal or his designee that is going to be serving as the officially designated representative, which is ODR. Same thing as it is in special ed. Does that answer the question? Okay, I'm going to assume that it do. All right.
She said yes.
Okay, good, very good. And keep asking the questions. I love questions because that way I know you're listening. That's why I like face-to-face better than Zoom and webinars. I like the energy of the audience. So please ask the questions. I'm thrilled with that. All right. Now, obviously, while 504 is a great thing, not every child's going to be eligible for services and supports under 504. So let's discuss how that eligibility is actually determined. Before a student can be determined eligible, someone has to indicate that the child has a problem. That someone can be the child's parent, a school official, or the child him or herself. The question often then arises, does the parent request have to be in writing? The technical answer is, it depends. And you see, while I'm not a lawyer, as I said at the beginning, I could answer a question like a lawyer. The truth is, it does have to be in writing. But what if the parent can't write? What if the parent doesn't speak English, can't write in English? The school is responsible to make sure that they get written, they get written permission from the parent. And it can be in any number of ways. The school can write up something in the parent's native language, and the parent can sign that. The parent doesn't have to physically write the request. They have to make the request. The school system can write the request, or a friend can write the request for them, but the parent has to sign. Without a signature, the evaluation cannot take place. So the answer is, we do have to have a written request. Now, what if the parent can't write, period? Well, can't sign their name, can't do anything. Well, then what they'll do is, like we do, this has been a long time ago. I haven't seen this done in a long time, but the parent will put an X and two witnesses will sign off that the parent made their mark. And the witnesses can be school district employees. It could be friends of the family. It could be one of each. It doesn't matter, but that's the legal way to do it. Make your X and have two people witnessing it, and make sure you have the school system needs to make sure they have identification from those witnesses. Remember, key is no evaluation can begin without written request from the parent. Now, when requesting 504 evaluation, the parent must indicate the areas of concern within that written request. And the reason for this is, what are we evaluating the child for? We can't just do, we don't want to just waste the child's energy and time, the school system's resources, with just a global evaluation. We want to know specifically what it is. Now, there may very well be multiple concerns, but we want to target it on what the actual concerns are. So when the parent indicates that they have when they're giving a written request for the evaluation, they need to cite their reason. And that reason can include academic, such as difficulty reading or comprehending the written text; behavior, consistently violates school rules and is routinely getting suspended; medical, the child has diabetes that might require visits to the nurse during class time; or any other types of things. The number of other reasons could be as numerous as the number of students in the school, because remember we talked about the definition of a disability under 504 was to be, it's purposely broad. We're going to talk about that in just a second to see what a vast array of disabilities, disabling conditions there are. We're going to add that in a few more slides. Now, the definition of a disability under 504 is very different from the definition under the Individuals with Disabilities Education Act. Under 504, a person with a disability is one who has a physical or mental impairment that substantially limits a major life activity. We will discuss substantial limitations in major life activities later in this presentation. Another criterion for the determination as to whether or not a person has a disability under 504 is that the individual has a record of such impairment, or finally, that the person is regarded as having such an impairment. Now, I got to tell you, for a long time, I had a hard time wrapping my brain around that one, regarded as having an impairment. but I did a lot of research and I had many discussions with attorneys. I went to several law conferences, and I know attorneys that work for our school system and people that do special ed law in general. And I learned that this criterion is not so much for the initial eligibility determination as it is about anti-discrimination component of 504. Whether an individual is or not determined to have a disability under 504, if another person takes action against the individual, such as bullying or physical aggression, etc., and that negative action is because the aggressor thinks the individual has a disability, then the aggressor can be charged with discrimination, even if the child doesn't have a disability under 504, because his actions were based on his thought that the person had a disability. So his intent makes him culpable legally. Now let's look at this list of major life activities. Looks pretty long, doesn't it? And these are some of the major life activities listed in Section 504 regulations, but those regulations clearly stipulate that this is not an all-inclusive list. Other activities that have been indicated include reproductive functions, functions of the immune system, normal cell growth, digestive functions, bowel and bladder functions, neurological, brain, respiratory, and circulatory functions. And even with all these added activities, the regulations indicate that this expanded list is not exhaustive either. The long list, coupled with the more relaxed approach to eligibility determination stated in the Section 504 law, makes it much simpler for a person to be eligible for 504 services than is the case for special education eligibility. And then remember, we talked about substantial, and not only does it have to have a disability limiting a major life activity, it has to be a substantial limitation. So what exactly is a substantial limitation? Well, that depends. There is no definition provided in the law, regulations, or guidance regarding Section 504. The 504 committee, using the evaluation data, must determine whether or not there is a substantial limitation. Some of these determinations are quite clear and easy to make. If a child is in a wheelchair, his or her mobility is most definitely substantially limited. But what if a child has a seizure disorder but hasn't had a seizure for 2 years? Is there a substantial limitation? That answer must be individualized to the child being discussed, and the answer may very well vary from one student to another and from one district to another. If the parent disagrees with the decision of the 504 committee, the parent has the right to follow due process procedures that each district must have that's outlined in 504. It should be noted that the courts have not to date defined substantial limitation, and in the end, it will probably be a court that will create some sort of definition. Until that happens, it is more than likely that it will be inconsistently interpreted across the United States. And that's the hard part. Same thing with special ed. When you have these words like reasonable, substantial, those kinds of words that are not measurable, they're more intuitive, people's interpretations can vary. And while my intent of the interpretation might be perfectly legitimate, the courts might view it differently. So the only way that there's going to be a definition is going to be if the court's suit is brought against some school district and the courts specifically address that issue. I'm not encouraging a lawsuit. I'm just saying that even with IDA that's been in place since 1975, many definitions have been created over the past 5 decades because of unclear guidelines, unclear definitions, and inconsistent implementation. The same thing is going to be true with 504. Now remember, before a child can receive any services or supports under 504, he or she must first be determined eligible. So what does that mean and how is it done? Let's talk about that for a bit. Before we do this, I'm showing you a poll right here. I'm going to also put the poll up here like we did with the pre-check. And if you would please just answer this question for me so I can get a feel for where you are with this particular topic. And then we will talk about this topic. Okay, looks like about half of you have answered. I'll give you another few seconds. All right, I'm going to end the poll now. There you go. Thank you for that person that just put the answer in. Going to go ahead and end it now so we can move on. Oh, and another one. I'm getting excited over here. You can't see me because I don't have my camera on. This is me excited. Thank you all for participating. I really do appreciate it. Okay. Okay, see if I can get this to the next one. All right. The simple answer is the evaluation is not a test. It is a process. So the answer to that poll was no, it is not just one test, or it doesn't have to be just one test. In order to determine eligibility, the school must conduct an evaluation. It must be understood that an evaluation is not just a test. It is a process. And this process will include some testing, but it may also include interviews with the parents, interviews with the student, interviews with the student's teachers. It's also critical that student data be reviewed in order to determine whether or not the student is having problems in the area of academics, behavior, communication, health, or in any other area, based on what the concerns were stated in the request for the evaluation. Some academic data that should be reviewed should include grades, standardized testing, scores like LEAP, progress monitoring data like STAR, Renaissance, and other things like that. Work samples are critical. Behavior data should also include at a minimal the number of office referrals and conduct grades, as well as attendance. And I'm going to give a caveat on grades. I know grades are important, and I'm a proponent of grades for the most part, but it is very specifically stated in 504 and in special ed, grades cannot be the determining factor for eligibility or for lack of eligibility. A failing student is not automatically eligible for 504 services, just like he's not automatically eligible for special ed. Nor is a student with straight A's automatically determined not eligible for 504. And there's a couple of reasons for that. One specifically is that grades, no matter how objective we try to make them, can be very subjective in nature. There could be unintentional grade inflation, and I'm not saying it's deliberate and it's malice. It is just a reality. There are studies that will show that a student who is a well-behaved student in class will typically end up getting a lot more consideration for a wider variety of responses by the teacher than a student who misbehaves in class, much less tolerance for deviation from what the teacher believes should be in that response. So, and again, that's not maliciousness, that's human nature, and we can't get away from human nature. So we want to make sure that we're looking at all the data, but grades, keep them in perspective. Now, also, we want to talk about communication data. Does the child, is he able to express himself adequately? Does he hear? Does he understand? So if he's not able to articulate his thoughts verbally as well as in written form, he's going to have problems in school. You want to review the data from prior hearing and vision assessments. You want to look at all those things. If they're past 7th grade, they have I think they still do the spinal test. You want to look at any data that's medical data that's available in the schools. You want to look at anything that would pertain to the concerns expressed by the parent. All right, now once the parents sign the paperwork, how long does it take for the evaluation? Once the permission is given, the school has no more than 60 school days to complete the evaluation report. Once that initial evaluation is completed, then the SBLC must meet to review the evaluation data and determine the eligibility of the student. It should also be noted that the process used to determine 504 eligibility is not supposed to be as rigorous as the eligibility process used for special education. This is included in both the letter and the spirit of the 504 law and regulations. So it's going to be easier for a child to be eligible for 504, not automatic, but it will be easier. The assessment process will be much less strenuous. And I'm going to give you a little, I think this is where I wanted to put this here, but I want to give you a little suggestion. When I was special ed director and 504 coordinator, nobody liked this idea, but I still like it. I think it's the best thing to do. If you believe your child has a disability, ask for a special ed evaluation. Don't ask for a 504 evaluation. If the school, as you know, there might be some times when you would want a 504 evaluation. If the child has ADHD and is performing pretty well, you know, that's fine. But most things, ask for a special ed evaluation. And the reason for that is simple. The process, the evaluation process is much more rigorous for special ed. So chances are if they're not eligible for special ed, they won't be eligible for special ed. That's okay. But when it comes time to being told that the child is not eligible for special ed, then you request a 504 evaluation. Guess what? They can use the special ed evaluation for that 504 evaluation. And now the bar for eligibility is dropped significantly. So now it's easier for your child to be eligible for 504. So then the question then becomes, well, then why do the special ed evaluation? Here's why. The more rigorous the evaluation, the more information the teachers have, the more information you have. And the more information that everyone has, the easier it is to develop FAPE, free appropriate public education for that child. If they're not eligible for 504 or special ed, look at the information. The evaluation team is still going to make recommendations. Well, the child seems to be having trouble in this area, not enough to warrant eligibility for 504 or special ed, but they're having trouble in this area. Recommendations to address this are this. Well, now 504 or special ed or not. The general ed teacher now has some things that they can use to help your child without the support of 504 special ed. And that's something that you know that you can be talking to your teachers about during the 504, during the parent-teacher conferences. It's just for your child's advantage. And remember when I said there is no funding for 504, but there is for special ed? Now, don't get me wrong, special ed is not funded adequately, but it is funded. So there are personnel that are being paid to do evaluations. So let them do it, because I can promise you they're probably better trained to do the assessments. The assessments are more rigorous it generates more information, and then the results will be more fruitful for your child. So that's my suggestion. And look, when I was special ed director, I told that to every parent that came and asked me anything, because I'm not telling you anything I didn't say as special ed director. I have not changed my opinions on anything, because you know what? The law hadn't changed. The financial structure of school systems hasn't changed. This is what I believe is in the best interest of the child. And people don't have to agree with me all the time, but it is something that you can certainly consider. All right. So now, how do we find out how do we make the eligibility determination? Well, the school building level committee will determine eligibility by answering 3 questions regarding the student. And what exactly are those 3 questions? Well, the first question is, does this student have a physical or mental impairment? The data contained within the evaluation report should indicate the answer to this question. If the answer is yes, then the nature of that impairment must be described. So you can't just say, yeah, they have a disability or an impairment. You have to say what that physical or mental impairment is. This would specify the disability under 504. It could be ADD, ADHD, a diabetes, seizure disorder, math learning disability, reading learning disability, anxiety, or a host of other possibilities. Let's walk through a fairly simple scenario, because most scenarios are a little bit more convoluted than this, but this is pretty easy to go through. So after an evaluation is complete, the SBLC reviews the evaluation, which contains medical records which state that the student has a diagnosis of muscular dystrophy. As a result of this condition, the student is in a wheelchair. So the answer to the first question is yes, the student does have a physical impairment, and the impairment is his inability to walk without assistance. Now, once the SBLC has determined that determined the presence of a physical or mental impairment, and it has identified the impairment, the next question that must be answered is, does the physical or mental impairment affect one or more major life activities? If the answer is yes, then the school building level committee must determine which life activities are affected and how they are affected. So let's continue with the example of our student in a wheelchair. It's been determined that he does have a physical impairment and that he can't walk without assistance. The major life activity that is affected would be mobility. So now we've determined that the student has an impairment that limits the major life activity and mobility. Now we must determine whether or not the physical impairment substantially, remember that word, limits a major life activity, and if so, which major life activity? Remember now, it's just affecting the major life activity, so that it has to be determined whether or not it is substantially limiting a major life activity. So this takes it to the next level. So in our scenario, the SBLC might well determine that there is a substantial limitation. But let's talk about the term substantially. Neither the law nor the regulations nor the guidance for 504 have provided a definition, as we've talked about before. So it is in each SBLC which must make the determination as to whether there is a substantial limitation. Because there's no definition, each team will use its own criteria to make the determination, and that sort of inconsistency will lead to disagreements and complaints. And that's what we talked about. It's going to take a court to make the decision. But in this example, it appears that all three questions have been answered with yes. So now what? In our example of a student with a diagnosis of muscular dystrophy who's in a wheelchair, the SBLC answered all three questions with a yes. So the student is, in fact, eligible as a person with a disability under Section 504, and a Section 504 plan should be developed. Now, you need to know, had even only one of the answers been no, then this student would not be eligible to receive FAPE under 504. And it doesn't matter which one of the questions. If the first question is no, that the student does not have a physical or mental impairment, then that's it. The process stops at that point. But in this case, each question was yes. If the last question would be no, then it would stop at that point. The end result is that the student still would not be eligible for 504. All three questions answered yes, they're eligible. Less than three questions answered yes, not eligible. And that's the law. Now, there are many areas of concern that can lead to evaluation of a student and to the determination of eligibility. One of those areas is academic. For example, if a child is reading well below grade level, usually at least 2 or more grade levels lower than his or her peers, and he or she is not responding to academic interventions, a 504 evaluation might be warranted. But the child could be struggling in math, following directions, etc., and those would all be academic concerns which should be investigated and addressed. Behavioral concerns might include repeated discipline referrals and suspensions, changes in overall behavior or mood, unusual aggression, or any other sort of behavior concern. All of the student's discipline data, along with interviews of the student, his or her parents, and the student's teachers, and any PBIS data which are available, are all good sources of data to investigate these concerns. Remember, don't overlook attendance either, because if students struggling academically, if they've missed excessively, that not being taught, or as we call it, ABT, ain't been taught, is not an eligibility criteria for a disability. If they're not present and available for instruction, their absence would not be cause for them to be eligible for disability, unless, because if you are not at school, if the child is not at school, then it's the school system's responsibility in conjunction with the parent to identify, why is the child not at school? Is the child not at school for medical reasons? And if that's the case, the medical condition could make the child eligible for 504. The attendance wouldn't preclude him from being eligible under those circumstances. The child has anxiety, and it's all you can do to get the child to school. Absences don't make the child eligible for 504. However, the anxiety might rise to that level. So there needs to be an investigation. You can't just, same thing with discipline. Why is the child being disciplined so much? Why are they breaking so many rules? There's an old adage. It's very important to determine, is the child's misbehavior a result of choice? Or is the choice that the child's making to misbehave a result of their inability to learn adequately? And so their frustrations lead their minds to believe, I'd rather be viewed as bad than as stupid. So what they do is to remove themselves from the stress of academic arena. They will get themselves out by misbehaving because they know that's going to send them to the office and get them out of the test, get them out of the instruction that they're having trouble with. So we got to determine the reason for those things. And that takes investigation. Asking the child alone will not always help. You really have to dig into it. And that's where parental knowledge of their child and a relationship between the child and the teachers are so important. That's how you learn motivation. Asking the child will just not do it. All right. So then the discussion of accommodations is where the rubber meets the road, so to speak, in 504 world. It must be first understood that a child can be determined to have a disability as defined by 504 and not be eligible for any accommodations whatsoever. One example of this might be a child with ADHD who's on medication and the medication is working. The diagnosis of ADHD will probably make him or her eligible for 504, but because the meds are working, she's not having any behavioral, social, or academic problems in school. Therefore, there's no need for accommodations. However, Should the med stop working, or if he or she stops taking those meds for any reason, parents can't afford it, any reason at all, a 504 committee meeting should be called to discuss accommodations and other supports that might address the student's new situation. The child can have a 504 plan and have no accommodations because, and the reason you want that is because one is entitled to it if he qualifies. And the other thing is a plan with no accommodation still affords protection, and we'll talk about this later, for the child for disciplinary infractions under 504. So we'll talk about that in a little bit, but you can have a 504 plan or an individual accommodation plan. They're called both things, and have no accommodations on it. It merely serves to identify eligibility criteria. So remember, the first thing to remember about accommodations is that the sole purpose of accommodations is to level the playing field. We talked about that earlier, not to give the student an advantage over his or her peers who don't have a disability. Any accommodation that's provided or denied must be supported by data. And those data must be obtained through the evaluation process initially, and subsequently they're obtained, like on an annual review, and we'll talk about that, they're obtained through the data that's collected over the year, student performance. For example, a student with a reading comprehension disability might be eligible for the accommodations of test read aloud, extended time, etc. But if the student has no disability in the area of math computation, an accommodation of a calculator would be inappropriate as the data don't support such an accommodation. So this goes to show the need for data to support any accommodation decision. We don't want to give students, we don't want to over accommodate and we don't want to under accommodate. Because one aspect of accommodations that must be considered at all times is if the child doesn't qualify for an accommodation during classroom testing, for example, that accommodation cannot be provided for state testing, LEAP. Typically, any accommodation that the student gets on LEAP must have been in place for at least 30 days before the administration of that state assessment. Otherwise, the accommodation can't be used on the state assessment. The reason for this is pretty simple. If the student hadn't had ample opportunity to use the accommodation to become comfortable with it, trying to implement it on the state assessment without practice will actually put him or her at a distinct disadvantage, which is contrary to the intent of the provision of accommodations, which should serve to level the playing field. And also, we want to remember the over accommodation, giving too many accommodations makes a child dependent on that when they don't need it. So it actually fosters dependence and is counterintuitive to the need for the student to develop coping skills and to become more independent as time goes on. If the student is determined through the evaluation process that he or she has a disability under 504, that student is entitled to FAPE, or free appropriate public education, under Section 504. So the discussion now must be about what, if any, services and supports the student needs in order for him or her to have equal access to the programs and grade level curriculum in which his or her peers without disabilities are engaged. Now, while the terms accommodation and modification are often used interchangeably, they are in fact two very distinct and different things. Using them synonymously is a slippery slope that can cause problems for the student and for the school. An educational accommodation is a support provided to qualified students that will level the playing field by minimizing some of the impact of that student's disability on his or her access to the general ed curriculum. But the student is still learning the same content and must demonstrate that he or she is learning that content to the extent required for his or her peers who have no disability. The way this mastery is demonstrated may be different, but the content will be the same for all. Whereas a modification indicates a substantial change to the content or to the level of mastery required. Only students who have the most severe intellectual disabilities are provided instructional modifications, and for the most part, those students would be identified as students eligible for special education services under the Individuals with Disability Education Improvement Act. So remember, accommodations, you're changing the content. Accommodations, you're changing the way the supports they get in order to learn the same content as everybody else. That is a crucial change. Once the 504 plan has been developed, all of the students' teachers are responsible to provide all of the accommodations. But if the student has behavioral issues, all personnel who have contact with the student are responsible for the implementation of any identified strategies. This could include bus drivers, cafeteria workers, clerical staff, janitorial staff, anybody who works in the school. You don't want a child who has a behavior plan in the lunch line and they engage in one of their behaviors and the cafeteria workers don't know anything about it. and they respond maybe as they would to anyone else, and it's completely inappropriate for this particular child, because initially that will start a problem for the child because he'll get in trouble. Subsequently, the child has already suffered that trauma, if you will, but now the staff needs to address the fact that they did not respond appropriately, so they were denying the student his due process, his rights. So at this time, during the 504 meeting, you need to ask the 504 chair when all appropriate personnel will receive a copy of your child's plan. If the plan isn't distributed, not only does that violate the law, but it also defeats the purpose of the accommodations, which require consistent implementation across the board in order for those accommodations to be effective. If the appropriate staff aren't aware of the decisions made by the 504 team, there is no way that any of those decisions will be implemented, and whatever problems have been present will continue and in all likelihood get worse. During the 504 meeting, when these plans are being developed, ask the team how the implementation will be documented and how those data will be shared with you, as well as with what frequency. You might ask to see charts and graphs that they create on a weekly or monthly basis. If you don't understand those data which are provided to you, don't be afraid to ask for a teacher meeting to have those data explained to you. So you want to make sure that you know, and that you ask the question of the school, when will everybody get the copy of these plans? And you can ask for evidence that those plans were distributed. And what we used to do is we would have a meeting with all the people, and we would have the teachers and the employees, the appropriate employees, sign off as a receipt. I've received the 504 plan for John Doe. I've received the 504 plan for Jane Smith. So we would do that. If the parent asked for it, then we could give a copy of that. And if the school system does an individual sign off for each student, that's not a problem. If they do a sign off, like with all the students and the teachers sign off on the same page, they can just redact or black out all of the information about the other students, but you can see who received what, and typically the date that they received it. Ask that. That does two things. It lets the school know that you're in tune with what your child's rights are, and it also keeps the school focused. It might get them, make it easier for them to remember that they have to do this, because now they, not only is it the law, but they know that you're going to be looking for this.
We have a question in the chat box.
Sure thing.
It says, do you have any suggestions for how to fight the feedback from a team that good grades prevent the child from being provided formal accommodations through a 504?
The first thing that I would do with that is remind them that grades are not a determining factor for 504 or special ed. And just like I said earlier, and just tell them this, good grades don't mean that they're not eligible. Bad grades don't mean that they are eligible. If there's a disability, that what you would want to do is have them support the fact that good grades mean that they can't have it. Ask them for work samples, because depending on what the nature of the child's disability is, you can look, if there's an essay question, let's say in an English class, if there's an essay question and you look at his work sample and he got a B on it, and you look, and he's in 9th grade and it looks like a 3rd grader wrote it, you make them justify that grade. That's where the problem is. Again, it's not, I don't think people do this to be malicious. I just think that it's human nature to try to give, especially if your child falls in the category, and I'm putting this in air quotes, adorable, just a joy to teach. I've said that about students, that your child is a joy to teach. I'd like to have 130 of them, more students just like him. That's great. I'm glad you have a relationship with my child. I'm glad you enjoy it, but I need him to learn. He needs to be taught and liked. So let's see what we can do in order to make this happen. So get them to justify that his good grades are supported, and also ask for other data, because a lot of times the grades, being subjective as they are, do not reflect the more standardized methods of measuring the student's performance. Like depending on what grade your child is in and what school district you're in, there's star reading and star math. It's progress monitoring tools. There are benchmarking that some districts do. Ask them for all of the progress monitoring information they have in the area that you're concerned with. If it's reading, ask for the reading progress monitoring. If it's math, ask for the math progress monitoring. But ask for that, and ask for it over the past year or more. And the reason for this is you not only want to see how he's performing today, you want to see how he performed a year ago. If today he's in 5th grade and he's performing at the 3rd grade level, which is 2 grade levels below, let's see how he did in fourth grade. If he was at third grade level in fourth grade, he's lost ground. That's a telling tale. If he was at third grade level, I'm sorry, if he was at fourth grade level, if he gained ground but is still below, that's one conversation. If he lost ground, that's another more serious conversation. But if he stayed the same, if he functioned at second grade when he was in fourth grade, then he functioned at second grade when he was in fifth grade, that year of instruction that he had in fourth grade added no value to his ability to process the curriculum. That is either a disability or poor teaching. And I would be very, very careful. I wouldn't say that to the teachers because that's like fighting words. And you don't want to get into a confrontation. You want to have a conversation. So ask for those data and really look at them. And if you don't necessarily understand the data, go to your local Families Helping Families Center, wherever you are. If you're in Lake Charles, go to the Southwest. If you're in Thibodeau, Houma, Lake, any of our region 3, come to us. We'll help you look at it and help you to interpret the data and give you some questions to ask, give you some concerns to raise, give you some points to make, and in certain circumstances, maybe even accompany you when you're having that parent conference. So that's how I can test grades. Grades are by definition not the criteria. They're not a sole criteria for eligibility or refusal of eligibility or accommodations. And so that's what you need to do. You need to look at it and be willing to listen to what the school says, because if the school says something that, okay, the child's grades are such that he's not eligible for accommodations, that's an inaccurate statement. But then listen to the next part of it. Are they explaining why he doesn't need accommodations? And maybe it has very little to do with the grades. Maybe it's just the way he is performing in class in general. Listen to that, get to know what their stance is so that you can either address it at a later time, or you might go, oh, okay, that makes sense. But ask for more data and ask for help if you don't understand the data. Those are the ways that I would do it.
Very thorough with the question. That's very thorough. So that was definitely helpful. So she said that was answering her question.
All right. I love this. Thank you. Thank you. Thank you. Thank you. So when we're talking about accommodations, over the years, I've heard many, for a common term now, fake news issues about accommodations. And one of them that there are mandated accommodation pairings, like if you have this accommodation, then you have to have this one. In most instances, that's not true. Because it's just not true. Contrary to what many people believe, it's true only on there's only one real automatic pairing. And that is if a student has answers recorded, then that student must also have individual testing. And the reason for this is that if a student is verbalizing the test responses so that an adult can record those responses, the student is not, and the student's not an individualized testing environment, other students in the testing room will hear the student's responses. And that will create a testing irregularity, which could void everyone's test in that room. Now, what's wrong with that? One is you no longer have data for your child from the LEAP test. Two is the school now has to pay $350, I believe is the most recent rate, to have your child retested. And three is if they don't offer a summer retest, then you just lose the data for that year. And while I'm not a proponent of LEAP at all, never have been since the very beginning of all of this stuff in the early 90s, I do believe that if we take the test, as much as we might hate it, let's use the data that we can use from it. And if your child misses a year, then that makes it harder to create a plan for next school year because you're not as clear on where he or she is lacking in that particular arena. So now, if a student has tests read aloud as an accommodation, he or she may also require small group testing, but not necessarily. Used to be, if you had tests read aloud, you had to be in a small group testing, and everyone in the group would be, the same test would be read to them at the same time. But now you don't have to do that. It may be if you have human let's say, how do you say, human read aloud. If you have a human reader, that's it. If you're getting your test read aloud by a human reader, then you have to be in a room only with students that are having the same test read aloud to them by a human. that is a mandated pairing. However, if you have text to speech read aloud, so basically the computer read aloud, the child can be in a regular classroom with everybody else taking the test, because they can be at their computer with headphones on. They can hear the test being read aloud. No one else can. So they can be in the room with everybody else. It's more of a logistical thing. Where is the computer plugged in? Where can the child be? But they're in the room with everybody else. So that's not even, the test read aloud small group testing is not even a mandated report unless it's human test. And having the need for having a medical condition and the need for extended time, that is not, that's no longer an accommodation, because your child might have to go to the nurse if they get sick, or if they have a specific time to have diabetes checked, or anything like that, or if they have a seizure, they need a snack, any of those things. Well, guess what? They don't need extended time as an accommodation, because every child is able to have that have that need met. And all it does is they stop the time of the test when that child leaves the classroom, and they resume it when the child comes back. And some people say, well, why is that? Well, there are a lot of kids who are not identified as special ed or 504. And this happens more than you'd be willing to know, and probably more than you want to know. They throw up during the test, on the floor, on themselves or whatever. They have to leave. That time stops for them. They go get cleaned up, and then they can resume the test when they comes back, whether it's that day or another day with the makeup days. But they don't have to have extended time, and they still get to have the amount of time that they are warranted, that is allocated for that test. So just having a medical condition or the need to see the nurse or anything like that does not give you the need for extended time. And there are a whole lot of things that are different now in the last several years. If it's available to all students, it is not an accommodation. Because remember, students with disabilities, whether they're 504 or special ed, are students first. So if it's available to all students, it's available to all students, whether they're 504 or special ed or not. So it's not an accommodation if it's available to all students. All right. Let me put this poll out as well. If you would answer this, I would be so very excited. All right, just answer this question. A Section 504 meeting can be held only once per year. And y'all won't appreciate this, but I'm gonna tell y'all how excited I am, because I was looking for 4 days for these polls and I couldn't find them. I just found them right before the presentation. I was not pressing the right button. So Renee, you were right. I was wrong. Stop laughing, Renee.
There's a question.
Yes, sir.
Involving a 504. They're using a human reader, and the mom was told that they could not pull the child out for the human reader to read the test. And they said that 504 didn't have pull-out time, so they couldn't do it because they weren't in special education. So they refused to do the human reader because they weren't, the person reading wasn't able to go outside the classroom to give it.
All right. And that is more common than you would like to know. But here's the reality of it. That statement is patently incorrect. The action was a violation of the student's rights. And here's what you do with that. The fact that they don't have personnel to do it is an administrative issue, which is completely, it's specified. Administrative convenience is not a reason not to provide accommodations. Once that 504 plan is written and the accommodation are on there, the district has to find a way to do it. If during the 504 meeting, they say we can't do this because they're not special ed and we can't pull them out, that is wrong. It's a child with a disability and you have to meet their needs. So what do they do? And I'll get a little bit more dicey with that. They have to find a way. And let me just tell you, small group, for one example, is not 4 kids in the corner in the back of the classroom, because when in the confines of that classroom, there's still 28 kids. That's not a small group just because they put 4 on the side. They have to pull them out into another classroom. the school district is right in that they can't put those 504 kids who are general ed students in the pullout classes with the special ed kids. And here's why on that. For special ed, it's specialized instruction. Their accommodations are part of specialized instruction. If they put regular ed kids in that room while they're testing, it is no longer specialized. It's available for all. So the 504 kids are getting their accommodation, but technically the special ed kids are losing theirs. So there needs to be, and staffing is a huge issue. Staffing is a huge issue, but staffing issue is not one that precludes the student getting the accommodations that they deserve. I would never ask this of the principal, but I might make a suggestion to the teacher when they telling us this. Well, are there not other personnel available who can provide this? For example, the principal, the assistant principals, the counselor, and all of those people should be testing if they don't have enough staff to meet all the accommodations. They have to. If they don't have enough staff in the building and everyone's doing what they're supposed to do, you ask them to please check with central office for available staff, because pupil appraisal center staff might be available to come and help you. I know in Lafourche Parish, we sent pupil appraisal staff to campuses annually, I mean, for every test administration. So ask them about pupil appraisal center staff. And those are your diagnosticians, social workers, school psychologists, speech therapists. All of those people can assist in administering these tests, and they can administer them to special ed students, or they can administer them to 504 students, or they can administer them to the full classroom while the classroom teacher is going to administer the 504 special ed students. So there's a lot of staffing. It's a matter of the district prioritizing staffing so that they can provide those accommodations. Don't let lack of staffing or lack of funding be used as an excuse for not providing it during the 504 meeting. That's unacceptable. And if they do want to do that, ask them to put it in writing. And that's going to make, if it doesn't make them sit back and think, they have bigger problems than that, because that's a bad thing. If they say they don't have the staff and it's already written on there, then you tell them, ask them to put that in writing, that they're not going to provide it and why. And again, that's going to force them, because what they're going to do, the principal, when you ask them to put it in writing, will typically call his supervisor, who will then call the special ed director or the 504 coordinator. And between those professional adults, I think there will be enough intelligence among them to realize they have to do something. Now, truth be told, they might talk about you lowering the dog when you're not in the room, but we don't care. What we care about is that the child gets what he or she needs, and that the school district provides the services that they are legally obligated to provide. And again, this is exactly what I would tell principals and teachers when I was a special ed director. I am not telling you something that I do not believe and that I did not live for many years. So I hope that answered that question, because that happens a lot.
Yes, it does.
Okay, good.
Thank you.
Thank you. See, every time I do one of these presentations, I've been retired for 3 years. I feel like I might still be relevant. You just never know. All right, let me go to the next one. All right. We talked about FAPE a little bit ago. What is FAPE? It's a free, appropriate public education. Now, notice that's 4 words, but they all have meaning. Free, which means no cost to you. And I should clarify that. It's no cost to you in addition to what everyone else pays. Like, they can still ask you to pay for supplies and field trips and things like that. They can't ask you to pay more because your child has more needs. Appropriate. That's one of those words that's not quite as defined as we would like it, but courts have defined it to some extent. So it needs to be appropriate to your child based on your child's circumstances. And that means based on your child's disability and ability to learn, is the school providing an appropriate education? Public means, again, it's public, it's free, it's open to everybody, and it's free to you. And education is that the child has opportunities to learn what everyone else is learning. So the 504 committee is going to determine FAPE through the review of data and discussion among the members, which includes the parent. You are a member of that team. You're not the captain of it, but you are a member of the team. The SBLC chair is the chair, not the captain, but the chair, organizing, make sure that all the responsibilities of people that are there, that you'll have the data that you need, that the meeting is scheduled and all that stuff. There is no head person in that. It's a team. Now, FAPE is important because it's sort of like the roadmap on a trip. FAPE's going to set the course that must be taken to get to the desired destination. If FAPE is appropriately determined or implemented, if it's not appropriately determined or implemented, the student will never arrive at the destination. And that's when you see lack of growth, the gap getting bigger and bigger, frustration starting on the part of the parent, the student, and the teachers. So we've got to create that roadmap, and then we have to implement it, monitor it, and improve it as we go along. Now, in order to ensure that the plan is being implemented and FAPE is being provided and it's yielding positive results for the student, the 504 plan must be reviewed at least annually. During this annual review, data from the past year should be collected and reviewed in order that the data-driven discussions may be conducted that result in decisions about whether to continue certain activities or accommodations, discontinue them, or add new accommodations. If we're not monitoring what's going on, we're never going to get where we got to go. So, the key is we have an annual review meeting, and you want to make sure that they give you data throughout the year. But if you're seeing that your child is not progressing, you want to make sure that you have a meeting before the annual review. You want to look at those accommodations, look at the implementation, because if you wait a whole year, that's a year lost. So don't overlook the fact that if they're not doing what they need to do or not succeeding the way you feel like they could be succeeding, have a meeting so that y'all can review that IEP long before the annual review is up. All right. Now, once your child has been determined eligible for 504 services, the 504 team must meet every year. We just talked about for the annual review. But there's also a requirement that your child be evaluated every 3 years or so. This reevaluation should include some new testing and a review of your child's progress over the past 3 years. Here's what you want to make sure. Those data need to be reviewed. If you see that the present levels of performance, what your child can accomplish right now is the same as it was last year or 3 years ago, that's a sign that it's not working and you'll need to do something different. Don't let them use the same data over and over. When it comes to the triennial reevaluation, make sure they do some new testing. If they did testing originally, make sure that they look at the data over the 3 years. Make sure they look at work samples over the 3 years, because without current data, the decisions that you have at this next annual review and the triennial evaluation won't be as good as they could be. And remember that the best way to see positive results is through data-driven decisions and courses of action. Old data or missing data will only impede your child's progress, and that's not something that we should ever let happen. Once 504, always 504. That's a question that I hear a lot. The short answer to that question is no. As we discussed earlier, your child will be reevaluated every 3 years. If as a result of any of those reevaluations along the way, your child no longer meets the criteria for 504, they can, and I'm going to say should, be dismissed from 504. This can also happen as a result of any significant change in information during the 3 years between evaluations. For example, it can happen when a medical diagnosis is changed or eliminated. However, in any case, I would always ask for the school to conduct a 504 evaluation, a reevaluation, so that the specific reasons for the discontinuation of your child's eligibility can be documented. This is good for you, and quite honestly, it's good for the school as well, because they can document that the decision was data-driven and not arbitrary. So if there's talk about your child not being eligible for 504, have them do the evaluation. That way it helps you to understand if their position is feasible or not. Now, if a child is found to be eligible for 504 services due to behavioral concerns, the 504 team should, with the assistance of someone with knowledge of behavioral principles, like a social worker, psychologist, develop a behavior support plan which identifies the behaviors of concern, as well as strategies which will assist in the reduction and or elimination of those behaviors. When y'all are developing this plan, ask who's going to help develop that. A lot of teachers have some good ideas, but they don't know the tenets of behavior like psychologists and social workers do. So it'd be very helpful if they would have some assistance from them. That's good for the teacher, and it's good for the effectiveness of the plan. And like any other concern, the student's progress on these behavior plans should be monitored frequently. The school should provide you the documentation of his or her progress, and meetings should be called whenever your child's progress is insufficient. And we talked about this, we briefly talked about this, the protection for discipline. So let's say once a student has been referred for an evaluation, he or she is protected under 504 in the context of discipline. This protection continues until such time as the student is determined not eligible for 504 services. This can be at the conclusion of the initial evaluation or even years later when the data indicate that he or she no longer meets eligibility criteria. Now, remember, this is once the evaluation has been requested. The child is automatically eligible even before they know if the child is eligible for 504. And it should be noted, however, that this protection only applies if the request for an evaluation was made before the disciplinary incident occurred. So if your child violates a school rule this morning and you ask for an evaluation this afternoon, your child's discipline will be the same as every other student would receive. If, however, you ask for the evaluation this morning and your child violates a school rule this afternoon, he or she would be protected under 504, and all safeguards and due process rights would be put in place to ensure that he or she gets is afforded his due process. So that's critical. A lot of times if a child engages in a misbehavior, the parent will ask for a special ed evaluation, which is a legitimate request. However, it will start the evaluation timeline, but it won't afford the child protection now. And their discipline will be the same as any other child. All right, part of the due process is a manifestation determination review meeting. So what is a manifestation determination or MDR meeting, and why is it an important part of your child's due process rights? Simply stated, it's a meeting to determine whether or not a behavioral infraction is the result of a choice on the part of your student, or if it was the result of his or her disability. If it is determined that the behavior was not a result of the student's disability, then the same discipline applies to your child as it would to any other student who has no disability. But if it's determined that the behavior is the result of the student's disability, then no disciplinary action may be taken against your child. This is true in all cases except where federal law mandates certain consequences. The 3 acts that require discipline, regardless of the presence of a disability, include incidents involving drugs or alcohol, incidents involving weapons, and incidents resulting in serious bodily injury to an individual. Now, please know, serious bodily injury, there's a legal definition for that, and it is a very high threshold. So if in fact your child got in a fight and bloodied a kid's nose or bloodied broke a kid's arm or anything like, ask them for the definition of serious bodily injury, the legal definition, because it's very hard to reach that. The person has to lose a limb or nearly lose a limb, nearly lose their life. It's that severe. Now, that doesn't mean that's an inclusive list, but serious bodily injury, if your kid gets in a fight and bloodies the kid's nose, that is not serious bodily injury. Now, the kid might think it's serious bodily injury. The other parent might think, but from a legal perspective, it is not. So that is not one, that would not involve this mandated disciplinary consequence. So if your child, if it's determined that that fight was a result of your child's disability and he broke the other child's nose, no discipline can be conducted. That's an administrative problem to deal with the other parent, but they can do no discipline. However, you do want to make sure that they do something. It doesn't have to be a punishment, but you want to, and they can't be a punishment, but they need to look at a behavior plan. Do they need to make a change to it? Was it implemented inappropriately? Do they need to add something to it, take something away, change something? Something needs to be done to address the behavior. It just can't be disciplinary in nature. And as far as the MDR, the manifestation determination review meeting, as a parent, you have a right to be present during this meeting, and you have a right to advance notice so that you can prepare for it with an advocate, an attorney, a friend, your child, or anyone else if you so choose. Don't let them just call you and say your child got in a fight at 11:30 this morning. It's 1 o'clock. You need to come pick him up. Well, when you're here, we're going to do a manifestation determination review meeting. If you feel comfortable doing it, you can do it, but I would say ask for more time because you have a right to more time. And that gives you time to process what's going on. You haven't talked to your child yet. You don't know what's going on. You haven't talked to the administrator yet. You don't need to find out firsthand what happened during that manifestation determination review meeting. Meet with the teacher, meet with the administrator, meet with your child, see what it is that happened, and then you can prepare and determine if you need a lawyer, an advocate, or just somebody from moral support there. So as a general rule, the MDR must take place within 10 days of the disciplinary infraction. It can be sooner, but it shouldn't be conducted until the administration has had sufficient time to complete their investigation into the incident. If there are witnesses to the incident and the administration hasn't had time to talk to all of them, then you don't want that MDR at that point, because they can't determine what discipline they want to recommend or shouldn't determine it until they know what actually happened. Now, the MDR is going to look like a typical 504 meeting, but someone with knowledge of your child's disability and how that disability might impact his or her behavior should be present. This could include a school psychologist or a social worker. A teacher who knows your child might be helpful, but they don't understand the disability to the extent that a psychologist or social worker would. That's what their studies are. So you want somewhere who's going to be able to do the relationship between the behavior and the disability. Now, once all of the information pertaining to the incident has been shared with the participants of the 504 meeting, then it's the responsibility of those present to answer 2 questions. Remember, we had 3 questions to be eligible. Now we're going to answer 2 questions to see if this is related to the disability or not. And you might be surprised at these questions. The first question is, does the student have a 504 plan that is reasonably calculated to provide the opportunity for the success of the student in spite of his or her handicap? In other words, does the 504 plan effectively level the playing field? If the answer to that question is yes, then you go to the next question. If the answer to that question is no, all bets are off. It is now related to the disability. So you don't go any further. The second question is, was that plan implemented with fidelity? And that means, did everyone involved implement the plan as it was supposed to be implemented, as it was understood by the team that it would be implemented? If the answer to that is yes, your first question was yes, this one's yes, then the child is going to be, his discipline will be the same as it would be for any child without a disability. If either of these questions is no, just one, doesn't have to be both, either of them, then it is considered the manifestation of the behavior is determined to be linked to the disability. If it is linked to the disability, no discipline can take place except for weapons, alcohol, tobacco, and serious bodily injury. Other than that, other than those 3 things, no discipline can happen if it is considered a manifestation of the disability. So, if your child has a disability that manifests itself in inappropriate behaviors, there should be included as part of the 504 plan, a behavior plan, which might be called a behavior intervention plan, a behavior support plan, or whatever your school district might call it. So what happens if your child has such a disability and doesn't have such a behavior plan in place at the time of the infraction? In that event, it can and should be argued that your child's 504 plan was not developed with sufficient supports to ensure the opportunity for success. So then the answer to the first question in this case would be no. So it should be determined that there is no causal link between your child's behavior and his or her disability. Similarly, if there is such a plan, but it determined that the plan wasn't followed as it was written and discussed, if that's the case, then once again, a link between the behavior and your child's disability must be acknowledged. In either of these cases, no disciplinary action can be taken unless it's one of those 3 cases we talked about. However, like we said earlier, that doesn't mean nothing should be done, because the behavior, the goal is then not to punish the child. The goal is to help to eliminate or at least minimize the behavior. That might mean looking at the behavior plan, either creating one or altering one as necessary. Again, if no link is determined, if both answers to those questions are yes, then no link is determined and the student will receive the same disciplinary consequences as any student who has no disability. It is this MDR process that is part of the entire due process afforded to students with disabilities and students with disabilities that serves to level the playing field, which, as you may recall, is truly the foundation of 504 legislation. But no matter how hard everyone tries, there's always going to be times when parents and school personnel just can't agree. If all forms of communication fail to bring all parties to consensus, then the parents have the ability to pursue their due process rights. Each district's due process will look a little bit different. But if you check the parent and student handbook that you receive every year from your school district, you should be able to find the process used in your school district. If you go to your school system's website, you should also be able to find this process in the policy section. Most of the districts will have levels, such as I've listed on here within this appeals process. The key thing, though, is to read the procedures carefully and follow them exactly as written. If there is a timeline to file the appeal and you miss their deadline, you will forfeit your right to move to the next level of the appeals process. So be certain about the timeline. Is it school days, business days, calendar days? Make sure you know exactly what they intend and meet that timeline. If you feel the need to go to the Office of Civil Rights, it will help you to show that you followed the school district's appeals process, and it will demonstrate your willingness to work with the school system. This sort of thing never hurts when you're going to OCR or any other due process proceeding. And I listed on here 4 levels before Office of Civil Rights. The 4 levels is just what the district that I was in used. But even we didn't quite stick with it quite that routinely, because for us, level 1 was to talk to the teacher. Well, by the time you get to the point where you want to follow an appeal, you've already done level 1 and you've done level 2, which is talk to the principal. To talk to them again, you might want to do it, and that's fine. The school district might require it, but I would not require that, because that just felt like, to me, pouring salt in a wound. You didn't get what you were looking for. Now, the principal and the teacher might have been perfectly right with what they said, but you didn't get what you were looking for. So why make you endure that again? So we would let you go straight to level 3, which would be to me. And I'm sorry, or my designee. And so then that level 3 would be coming to another party, somebody off the school campus, somebody in the central office. For us, it was somebody in the pupil appraisal center, a psychologist. You talk about it, and then a decision's made. If you're not happy with that, then you go to level 4, which would be the superintendent or me, because I was typically the superintendent's designee. If you're not happy with what comes out of our meeting, then you can go to Office of Civil Rights, or you could even file a complaint at the with the state of Louisiana Department of Ed. So read what it is, and the key is to make sure you follow it to the letter. Don't miss the deadline, because we are within our rights if it's posted, if it's part of policy, if it's part of the procedure. If it says your written request for an appeal must be received within 5 days of the MDR, and you get it to us 6 days later, it stops. That's it. You've lost your appeal. Now, you can still go to Office of Civil Rights, but you haven't complied with that. So that may not help you at the Office of Civil Rights. So just keep that in mind. It's very critical that you read it very carefully. And also, you want to look to see if it has to be signed, because if it has to be signed, an email won't suffice. So you want to be very careful and very meticulous about that. All right, if you would, please, this poll right here about parent rights, if you would just answer that question for me. And for those of you that are getting tired, we are almost finished. All righty, I'm going to end the poll now. And that poll question is: parents' rights information must be provided at every Section 504 meeting held. Let's talk about that for a minute. Parents' rights need to be provided to you at least once a year, usually at the annual review meeting, not at every 504 meeting. However, if you lose your copy or you just want an additional copy, you can always ask for an additional copy, and it is to be provided to you free of charge. When I was a special ed director and the 504 coordinator, we tried to give a copy of the rights to a parent at every 504 meeting, not because it's required, but because if we forgot one time along the way, there's always documentation that you got at least the one that's required every year. So we did that. It gives you the rights. We make sure you have the rights and make sure that we're in compliance. All right. Now, all right. If you see on your screen, these are the same questions that you saw at the beginning. So I'm going to post this right now. If you would please answer this. The purpose of this is so I can compare your answers at the beginning to your answers at the end and see if what we've done has hopefully lent more knowledge, to provide more knowledge for you so that you can be more involved in your child's education if your child requires 504 supports. That's the goal. So that's the reason that we're doing this. So if you would please, oh, here it comes. I'm sorry. If you would please answer those. And we do use these data to see if we need to make changes to our presentation. Because while you're doing this, I will say the State Department does not offer any training or support guidance on 504 to the local school districts, whether they're charter or traditional school systems. And so a lot of times school districts will make mistakes, but it's not out of maliciousness. Sometimes it's just out of not knowing and not having anybody that can assist, answer their questions for them. So if you know the right questions to ask, and that's what I'm hoping that this will give you a brief overview. So it gives you enough to ask some questions. It forces them to look into it, because no school district is going to willingly do something wrong. And when I mean wrong, I mean against the law. If they knowingly and willingly do it, they're going to be very culpable. If it's a matter of them doing a little research because of a question you asked, you've done them a service and you've done your child a service. So until the State Department affords more guidance, your questions are probably the best training tools that school systems will have. And I will say that's a sad state of affairs. Okay, I'm gonna leave this up for another 10 seconds. All righty. Thank you all very much. Going to end the poll. All right. Now, during the course of this presentation, I hope you've learned a little bit about what Section 504 is, that it's a law that was passed to help your child to have the level playing field that will eliminate much of the barriers created by the presence of a disability. I hope that if your child has no academic disability, can he or she be eligible for services under 504? I hope that you've learned that it doesn't have to be an academic disability. It can be a medical, it can be behavioral. There are a whole host of disabilities that would make your child eligible for 504. And how can 504 help students with disabilities who are struggling in school? Support. And part of that support might include accommodations. It's strategies, instructional strategies, accommodations. There are a host of things that can be done if a child is eligible for 504. Now, I'm gonna be perfectly honest with you. Not too many things that you can do with 504 can't be done if you're not 504. That's not true of special ed, but that is true of 504, because 504 is general ed. But having a 504 plan helps the school to focus on your child more than they would if they didn't have one. And it helps to address those. It gives a higher level of accountability. While it's sad that that is necessary, I think it's something not to be underestimated or overlooked. There are a plethora of accommodations that can be part of a 504 plan. For academics, it can be extended time, test read aloud, small group testing, individual testing. It can be something as simple as your child is overwhelmed by the amount of print on a page. You can either do one question at a time. They can have a little cover slip. They can move down so they only see one question at a time. You can print the test, one question per page. If they have visual problems, you can just type it up in big type. There's a whole bunch of things for academics. Behavior plan, if they're having behavioral things, regular consultations with the counselor or with the school psychologist or social worker, if it's behavioral. So there's a whole lot of accommodations that can be individualized for your child based on your child's disability. And how do you better understand 504 as it pertains to your child? Please, you can read up on it. You can call your Families Helping Family Centers. We'll be glad to assist you. If we don't know the answer, we will find out what that answer is for you. That is for sure. So now I'm going to ask, are there any more questions?
Person asked a question. Can you email us the PowerPoint used for this presentation?
We will email the PowerPoint, and we're going to email it, and I'm going to include the comments, the things my notes that I made that basically I'm reading off of to make sure I get all the points. So you will have that. My only request is that please don't change it, because if you change it and it's something wrong, I'm going to look really, really bad. But it will give you the information that you need, including our contact information. So if there's something on here that you don't understand, please call us. We'll clarify it. We'll help you if a unique situation comes up with your child at school and you can't find the answer in this presentation, because 504 is very broad. And even though this has taken close to 2 hours, we've barely scratched the surface on some of the details. So call us. We'll be happy to help you out. But yes, you will. Renee, my education liaison, will be mailing this out to y'all, emailing it probably in the next, what's today, Friday? Sometime next week, you should have it along with a certificate of attendance. Any more? And here is our contact information. This will be part of the PowerPoint. You will have this. So it has my email address. And I put Susan Reen is the executive director. She's with Wallace. But if you go with that email address and that phone number, you can still get in touch with Wallace at that same at those same numbers. And if you do my email address or that phone number, you will also have access to Renee Fry, who is our education liaison. So this will be part of that, so you can keep that handy.
The person is asking in the chat, do you need our email address so that we can get the PowerPoint?
I believe that all of that was put in when you registered. I asked for that. I believe the email address was one of the required. If we don't have your email address for some reason, your phone number, I think, was put on there. So we will call you and make sure that we have their email address. And if you don't get the email with the PowerPoint by next Friday, call either of these numbers and we will make sure that that gets to you. Because Wallace, if you get a call, you can let us know and we'll send it out, or you can send it out because I think you have it.
Thank you, sir.
Okay. And again, I end all of our presentations with this. I'm not a lawyer. Remember, anything presented tonight is not intended as legal advice. And the context of all answers is probably what happened this way, given the circumstances that you have provided for me. And while I am not a lawyer, I do have some adorable kids. That's my babies. So I just want you to know we are all parents together. We all fight the same battles. When the kids were little and cute, we were fighting battles, blazing paths, just like y'all are doing now. Y'all hopefully are some different paths than we blazed, but we work together so we can make it better for everybody. Any battle you fight and win, any path you blaze, makes it easier for the next group of kids with disabilities and their parents to come through and get what they're entitled to so that they can have equal opportunities.
In the chat, someone's asking, could you please put back up the contact info again so that they can get it? Certainly. And there's also a lot of thanks in the chat. Thank you for doing this. Thank you so much. This was helpful. Thank you. Thank you. That's in the chat as well. Well,
great. I'm glad it's helpful because really, truly, it's overwhelming when you start navigating a system, whether it's 504, special ed, or just the educational process. It is overwhelming. So if we can put a little dent in that and make you feel a little more comfortable, that makes me feel like we're making the difference that we want to make. And I'm going to ask you to, I've got it set up so after this presentation is over, the evaluation should come up on your screen. If it does not, you will get it in the email within a matter of probably a few hours or tomorrow, but it should come up immediately after you get off. If you would, please answer that and send it back, because that helps us to justify if we have met your needs and to what degree we have. It's very short. It's like 7 questions, very easy. And also we will enter your name in the drawing for the laptop at the end of November. Okay. And if you're having trouble writing this down, you can do a screenshot. That'll give you everything you need. But you will have this information early, sometime next week, hopefully earlier than later next week. And just so you know, this is the ugly mug that's been talking. I want to thank you all for coming. Thank you for your patience. Oh, look, it's two ugly mugs. Look. That's Wallace. That's our co-host from Southwest Family Southwest Louisiana. So I thank you all for coming. I appreciate it. And again, do not hesitate to call. That's why we're here. That is what we do. We want to make your life a little bit easier if we possibly can. And good luck to you all. And it doesn't have to be related to 504. If it's related to anything about your child and services they might need for based on their disability, call us. If we don't know the answer, we can direct you to someone who does, or we can find the answer for you. Y'all have a great weekend. Enjoy this beautiful weather. Fall is upon us, and it's going to be just a lovely weekend. So cut grass to your heart's content. Y'all have a great weekend. Thank y'all all so much for coming.